Okay, well, hello everybody, and welcome to this Q&A session we're running on the General Data Protection Regulation. My name is Vincenzo Ardilio, and I'm Iris's Data Protection Officer. And your questions have been coming in thick and fast over the last week or so. In fact, we've had well over 400. So we've had lots of questions asking what's going to change, what are the new rules, and so on. So I'm going to give you an overview of the new regulation. And over the next half an hour or so, I'm going to do my best to answer as many of those questions that have been coming in as I can. So just very briefly, just by way of introduction, a bit about myself. I won't bore you too much. But I've been involved in data protection for the last 17 years or so. So unfortunately, I'm old enough to remember when the current Act was coming in, the 1998 Act. And just like GDPR, that was seen as a huge improvement over its predecessing law, if you like, the somewhat wishy-washy 84 Act that it was replacing. And obviously back then, the internet, email, digital services and so on, they were nowhere near as widely used as they are now. And if at all, to be honest, and inevitably the law has had to do quite a lot of catching up to keep up with the digital age. And the GDPR is an attempt to do that. And I would argue it's actually not a bad attempt to do that. So what we're going to do is we're going to highlight the following based on the questions that have been coming in. So hopefully my slides should change in a moment. Bear with me. We seem to have a freeze situation going on here. Right, here we go. So the areas that I'm going to highlight are what you need to know first. So we'll cover the timescales, which many people have asked about. We've had a lot of questions about privacy notices and policies, so we'll take a look at this area in some detail. We've also had a number of questions about the rights that GDPR brings in, lots of concern about the right to be forgotten and how that might conflict with the statutory retention periods and so on, so we'll touch on that too. A number of you have asked simply, what do we need to do? Now, I should stress that in the very limited time that we have, there's a lot of important stuff that I won't be able to cover. But one area that I think you do need to know about is this area that you can see on the bullet list there, is the area of data controller process and relationship. And I'll explain what that is, so don't worry. And I'll explain what it means to you. And I'll do my best to point you in the right direction, I think. I'll highlight the key issues that might affect you and your practices and where you can do further reading from official sources such as the Information Commissioner's Office. So obviously we'll also look at some of the other key changes too that people have been asking about. So by the way, anyone not familiar with the term data controller, which I've just mentioned, and I'm going to mention it a few times as we go through, it basically means the decision maker, so the organisation that's the decision maker. So you as an accountant or your accountancy practice, for example, you decide why and how you'll use your client's personal data. So that puts your business in the category of data controller. And that's important because data controllers have a lot of responsibility when it comes to complying with GDPR. So that's like the first takeaway, if you like. So what do you need to know first off? So those that ask about timescales, the GDPR is replacing the current data protection laws, and that will happen on the 25th of May next year. So 25th of May 2018. It's bringing a new age of compliance and accountability, as some have said. Now, a lot has been said about large fines for organisations. As you can see, that's highlighted on the slide here. They can reach up to 4% of your annual worldwide turnover, or 20 million euros, whichever is greater. And admittedly, that does contrast starkly with the current maximum of €500,000 under the Data Protection Act. But aside from the enforcement, you'll just know that from news coverage over the last couple of years or so, the data protection breaches are actually seen as pretty newsworthy. So apart from the fines, there's the reputational risks if we as businesses don't get it right. But aside from that, what I don't think enough is said about is actually the huge reputational advantages of getting it right. You know, forgetting all the enforcement and so on. You know, this is all about trust people trusting you as a business. You know, the more that we can build trust by complying with the laws we're supposed to comply with, the more people are going to engage with us as a business and engage with you as accountants. And finally, for those that have asked, you know, what does it mean for us? If there's one thing that you should take away from this session, the regulation is all about accountability, and you're being able to evidence your thought processes and, you know, so evidence in your compliance with the law. So that's really important. Now, another question is, you know, is it actually going to happen? Some of you want to know, obviously, because the elephant in the room is that this is an EU regulation. So I often get asked whether this is really worth worrying about because of Brexit. Well, the short answer is yes, and here's why. Assuming 2 years from the triggering of Article 50 at the end of last March, so we'll have around maybe a year or so of the regulation applying as a direct regulation on the UK. You may also be aware that the UK's Information Commission, in fact the government, was quite involved with the other commissioners around the EU in putting the regulation together, so that there's, you know, investment in there already. And also back in September, the government published its new data protection bill, which is the law that will kick in once the UK leaves the EU and becomes the new UK Data Protection Act. So basically, the new UK Data Protection Act will be kind of GDPR under another name, as well as some other stuff. It doesn't just concentrate on GDPR, but it does bring in GDPR into UK law. So basically what I'm trying to say is that the requirements of the regulation and any UK successor to it is a reality, and it's going to be here for, you know, a long time to come. So having established that we need to take notice of it, let's get down to the nitty-gritty. You know, questions that came in was, you know, what does GDPR actually apply to and what does it require? So let's start looking at that. So what does it apply to in the first instance? Well, if you're familiar with data protection, you'll know that it's all about people. That's the key. So it applies to all information about identifiable living individuals, so personal data, in other words. So in the accountancy context, this could be your clients, your employees, and so on. And yes, it does include electronic and hard copy. So if you've got everything in Lever Arch files, as I know at least one of you has because you asked about it, then this is covered by the rules, as long as the files are structured in such a way that you can put your hands on the personal data of specific clients or people. So yes, manual information is just as within scope as electronic or digital information. Now you'll see that there's a blue slice there, anonymised data. So completely anonymous information is not within the scope of data protection or the GDPR. So when I say completely anonymous, I mean you really can't know who the information is about. There's nothing about the information that would allow you to identify anybody. And then the final slice is this idea of pseudonymized data, which has been brought into the scope of the regulation, which is why it's coloured red. And what that is, if you're not aware of it, it's kind of temporarily anonymised information. So it's often used when testing systems, when it's too risky to, you know, use live data. So that's pseudonymized data. It's actually promoted in the GDPR as a security measure as well, but that's within the scope of the regulation. So hopefully that's clear what it actually applies to, but what does it actually require? So here we go. So like the current Data Protection Act, the regulation has two compliance areas. So you can see on the slide there, we've got the data protection principles, and these dictate the how. So that's how you must manage personal data. And then the other side is individual rights. So these put your clients and any other individuals who are the subject of your information, it puts them in control. It gives them power and rights over the information you're using about them. So let's look at the data protection principles first. You've got 6 of them, and reading across the slide, I'll read them out and give them some context. So starting with A, we've got the requirement to use personal data lawfully, fairly and transparently. We're going to come back to that one. B, we've got purpose limitations, so using personal data for specific purposes and limited purposes. Then we've got C, data minimization. So this is really about using the least amount of personal data that you need in order to accomplish your purpose. So it's not about collecting as much information as possible because it might come in handy. That would be the opposite of data minimization. And then D, we've got accuracy. So this is all about having processes in place to make sure, to the best of your ability, that the information is accurate and up to date. Especially important if you're making decisions about people or if decisions are being made about people based on your information that you're holding. And then we've got storage limitations. So this is about not keeping the personal data any longer than is necessary for the purposes you've identified. And then finally, F, we've got integrity and confidentiality, or as we all tend to refer to it, information security. Now, there's a lot more flesh in the regulation about this, but they are still purposefully broad in recognition that each business and each business sector is very different. So just to give you an example, some of you have asked, well, how long should we keep records for? Well, the answer is the regulation doesn't tell you how long you have to keep records for. It's down to you and your business to decide what your requirements are. And you should only keep the personal data records for as long as you need to for those purposes. So you may need to look at other legislation that you operate under. You may need to look at common business practice in the accountancy sector, for example. But really the key here is making sure that you have some kind of process for getting rid of the personal data once you no longer need it anymore for your business purposes. So not keeping hold of it just in case it comes in handy later for no specific reason or because you really haven't got around to disposing of it. That again would be the opposite of storage limitation. And ideally you want to document what your procedures are. As you can see from the red square at the bottom of the slide, this is referred to as the accountability principle. It says the controller, so that could be you, your accountancy practice, the controller is responsible for complying with these and must be able to demonstrate compliance. So if ever there's an incident or something that gets reported to the Information Commissioner concerning your practice, they will be asking you for evidence that you comply. And the best evidence you can keep is documenting your procedures and what your business practices are. So documenting your retention periods and what your processes are for getting rid of information you don't need anymore. Now, similarly, for those of you that have asked what security measures to put in place, again, the regulation doesn't go into any detail. It's down to you to decide what's proportionate, given the sensitivity of the personal information you use. And again, what current best practice is in the business sector. And you know, to be honest, there's loads of information out there on information security. The government has published the Cyber Essentials Standard or the Cyber Essentials Scheme. And there's also a kind of a step up from that called the IASME. And then there's the Rolls-Royce Standard, which is the ISO 27001. Security standards. So all of these standards are kind of designed to help you to identify what security you need to put in place. Remember, you know, security isn't just technical measures, it's also kind of, you know, around, you know, your physical security of your offices and that kind of thing. But while we're on that subject, to answer another question, a few have asked about emails. Had questions like, is it going to be illegal to use them? You know, can I still send information via email? To be honest, I'm not sure what's happened to make people particularly worried about emails, but basically the regulation doesn't change anything. Just as now, normal internet emails are not considered a secure way of sharing confidential information over the internet. Think of them as a postcard. And bear in mind that a good proportion of data protection breaches, going back to 2012 when the ICO started having the power to fine organisations for breaches, some of the first breaches were around emails, usually through sending them to the wrong person, hitting reply to all, and so on and so on. So emails are not a secure method of sharing personal data, especially sensitive personal data or anything that could have an adverse impact on somebody. So if you do need to share confidential information over the internet, either find a secure email solution, and there are some good ones out there, or look at a secure file sharing platform, and I know Iris has one, so ask your account manager if you want to know more about that. But basically, to answer your question, normal emails are not a secure method for sharing information over the internet. So kind of just to summarise the principles, what you need to do is look at your practices around keeping your information secure, for keeping to those principles that you can see on the screen. Unfortunately, we can't go into each one individually because they're all quite big subjects in themselves, but do some further reading. Think about how you'll evidence that you comply with them, because like I said before, that will be crucial if you suffer a breach that's reported to the ICO. Now, I said I was going to come back to the first principle because there's a big change under that I think you should know about. And definitely, as consumers, we're going to think of this as an improvement. Maybe businesses won't have the same view. So this is around the area of privacy notices. The legalistic T's and C's type of documents and scripts that we're often asked to read and agree to whenever we sign up to something. And most of us, let's be honest, we don't read. Now, we've received 1 or 2 requests for Iris to provide a standard privacy notice for you, and I'm going to tell you why that's not a good idea. So let's think about that. So we've established that the first data protection principle says that you have to use personal data lawfully, fairly, and transparently. And to achieve this, you have to provide certain information to people affected by your activities. So most of you won't be relying on consent, you'll be relying on a contract with your clients. But you must still be transparent with the people affected by your use of their data. Now, the current Data Protection Act is quite vague as to what you need to do, to provide what information you need to provide and when. But the GDPR is pretty specific as it lists in detail what you must explain to people that you use information about and when you must provide that information. So one of the issues that I want to highlight is this. Businesses need to get away from the T's and C's kind of legalistic approach that we're used to at the moment. So you must make your privacy information readable, plain language and transparent for your audience, most likely your clients. So some businesses are thinking outside the box. I've heard some people suggesting that they'll do it through a video rather than a big script, and maybe that's not a bad idea. You might decide to do it through either adverts or your letters of engagement or any other medium that you engage with your clients with. So think about what's suitable for the way that you do business and the way that your clients engage with you. You should definitely bring any non-obvious use to your client's attention. And what I'd say, because again, this is another big subject we can't really cover in detail here, have a look at the Information Commissioner's Code of Practice. It's called Privacy Notices, Transparency and Control, a code of practice on communicating privacy information to individuals. So have a look at that. But having said that, we're going to look at an example now. So here's an example. Poor pharmacy to you. They're probably used in many training sessions in data protection. But here we've got this privacy notice. It's an extract actually from the privacy notice that, or one that they used to have, I should say, that says occasionally we make details available to companies whose products and services we think may interest our customers. If you do not wish to receive such offers, please log into your account and change the setting to indicate no for selected company data sharing. So would you say that's unusual, or would you say that's kind of in line with what many of us have read? I'd say it probably doesn't look a million miles away from some of the scripts that I've read in the past. But remember that I said that you need to bring to your client's attention any non-obvious use made of their data. So that's where the context comes in. So let's add some context. So pharmacy to use customers are mostly elderly and infirm. This is going back probably about 5 years or so, I think. The information that they were using, or that they were selling, should I say, included some quite embarrassing medical conditions that actually most of us wouldn't really want shared. And they were selling these to a lottery company and a health supplement supplier. So now that you know the context, would you say that the privacy notice that you can see there, is that adequate? I would argue no. And the mistake that all of us businesses have made in the past is that maybe we've approached this from a kind of a limiting our own legal liability approach rather than being genuinely informative to customers. So in your business, the aim is to help your clients and others to understand exactly how they're going to be affected by your use of their personal data. So think about anything that you're doing with personal data that your clients wouldn't know about and that they would be likely to object to. That's exactly the kind of information that you must include in your privacy information. I'll mention again that how you provide this information is up to you. It depends on how you engage with your clients. Ideally, you provide privacy notices in the same way that your clients engage with you. So that's privacy notices. We've just covered one important aspect of the first principle of transparency. And actually, this kind of leads us nicely into the next issue, so the rights. So there were two aspects of data protection, or two main aspects, I should say, the principles and the rights. So this particular one about transparency overlaps with the right to know. So let's have a look at this. So by my counting, there are 10 specific rights that I think you really do need to know about under the regulation, but we've got time to mention one or two of the most important ones. Now, I mentioned at the outset that the regulation's ethos is accountability for businesses and organisations that use personal data. It aims to put the individuals in control. So that's why you can see that there are these bigger sanctions for businesses and organisations that refuse to get it right. But in terms of the specific rights, your clients can make a subject access request, just like they can under the current Act. So this is when someone asks for a copy of the information that an organisation holds about them. So for example, someone could ask you for a copy of everything you have about them. The main change there, if you like, is that the timescale for dealing with it is now 1 month instead of 40 calendar days. You also need to know about the right to data portability, that individuals can ask for a CSV file or a reusable file of the data that they previously supplied to you, so that they can transfer it somewhere else, maybe to another accountant. It's really up to them. So really, the kind of the message is that you need to make sure that you can handle these rights, not only for requests for the data that you hold about people, but also if people want to correct or delete inaccurate information and so on. And in certain circumstances, they can ask you to restrict how you're using information or completely object to using it for a specific purpose. Now, on the subject of rights, so one of the questions that came up was the subject of erasure, so often referred to as the right to be forgotten. So someone has asked how that squares with a statutory right to keep client information for 7 years. Now, I don't know whether you're under statutory obligation to keep client information for 7 years, because I'm not an expert in accountancy law in particular, but let's assume that that is the case. The answer is, don't believe the press. If you believe the press, you'll kind of get the impression that the right to be forgotten is kind of, there's a universal right that we all have to just ask anyone to delete all our data if we want them to. But actually, the right to be forgotten is very limited. So, going back to the question at hand, if you're under a statutory requirement to keep client data for 7 years, then that statutory requirement will take precedence over this right to be forgotten. but you do need to be in a position to justify your decision. So just to summarise the rights then, you need to think about how you're going to handle requests that come in under these. You might not get many, let's be honest, but just be prepared. And ideally you need to document this, have a kind of a formal procedure for dealing with them. So the next thing I want to do is talk about the relationship between service providers or data processors and data controllers. Remember I mentioned earlier the controller is the entity that decides how and why personal data is to be used or processed. A processor, on the other hand, is a separate legal entity, so not an employee of the controller. It's a separate legal entity that acts under your instructions as a controller, and they act under a formal contract. So, for example, if Iris hosts your business data, then Iris is a processor on your behalf. Now, under the current law, data processors have next to no liability for complying with data protection requirements. They only have to comply with the agreement that you have with them. But here's what you need to be aware of, and I can see the first two bullets have appeared on the slide. So basically you must carry out due diligence on any processes that you use, and you need to make sure that there's a contract or an agreement in place that meets the GDPR requirements, and the regulation lists in detail what these are in Article 28. Also, good news for you is that processors must also help you to comply with the regulation by, basically by letting you know of any non-obvious uses or processing of personal data that you might need to tell your clients. And they need to help you to comply with certain other parts of the regulation. Now, unlike the current law, the processor does have some direct responsibility for security, and they can be subject to fines in their own right. So as part of that, you're going to want your processor to report to you any breaches that they become aware of that involve your personal data or the data that they're processing on your behalf without undue delay. So you should check that you have these arrangements in place and that you know what the processors are doing with your client's data on your behalf. Now we're going to mention very quickly a couple of other changes brought in by the regulation that a few of you have asked about. So just a very quick mention of this one. So this is the data protection by design and default. It's a theme that runs in the regulation. It basically includes carrying out a data protection impact assessment if you're doing kind of high risk stuff with sensitive personal data. But really what it's all about is just designing in data protection compliance into your service. Or into your systems or your ways of working really. So rather than bolting compliance on at the end as kind of an afterthought, it's about building it in from the beginning. It's quite logical really, isn't it? The Information Commissioner has produced guidance on this, and in fact they have a code of practice for data protection impact assessment. So do think about how you'll keep evidence that you comply with this requirement. Now, many questions came in about the data protection officer. So, do you have to have a data protection officer really? I think the questions were along the lines of. So the answer is that only certain organisations are now required to formally appoint a data protection officer. So namely public authorities. So if you're a public authority, the answer is simple, yes, you do have to have a data protection officer. Apart from them, any business entity that uses sensitive personal data as kind of a core activity, they have to have a data protection officer. Or if they carry out high risk uses or monitoring of people. So, for example, an organisation that runs a public CCTV scheme, for example, where there's likely to be a high impact on people if things go wrong. Or if people's rights are infringed, then they would need to have a data protection officer too. So the data protection officer role is an advisory and monitoring role basically, and it's defined in detail in the regulation. There's also lots of guidance out there. In fact, the EU Article 29 Working Party, a bit of a mouthful, but they are basically the working group of EU Information Commissioners. They've issued detailed guidance on the data protection officer role and how you can decide when you need one. And I recommend that you check out, you could Google it, Article 29 Working Party Data Protection Officer, Google that, find the guidance. But my feeling is, my gut feeling I say, is that, it's unlikely that a normal accountancy practice would fall into the category of a business that needs a data protection officer. But really, you need to take the ownership of that decision yourself, and you need to kind of look at the guidance and make that decision. Now, what I would say though is even if you don't need a data protection officer, I do recommend that you have a data protection lead. So even if you're not required to formally appoint one, don't call them a data protection officer, because otherwise they will still have to carry out the statutory functions in Articles 37 to 39 of the regulation. But it is a good idea to at least have someone who's leading on data protection for your practice. Now finally, a big area that we've been asked about is reporting breaches. So firstly, what is a breach? So you can see the regulations definition on the slide. I'll give you a few moments to kind of read it. But basically, a personal data breach is a security failing, and it affects either the confidentiality, the availability, or the integrity of personal data, or it could be any combination of those. So confidentiality, availability, or integrity of personal data. So what you must do is you must notify the Information Commissioner of serious personal data breaches without undue delay and within 72 hours of your discovering it. Now, if the and I should say that that's the serious breaches where there's likely to be a risk to the rights and freedoms of people. Now, if the breach puts people's rights or freedoms at high risk, as opposed to just risk, then you must also notify the individuals affected too. So my recommendation is that you're going to need to keep a record of all incidents and breaches, even the ones that you decide not to report. And again, this EU Article 29 Working Party, they have issued guidance about breaches. Back in October, they issued this guidance. Again, I recommend you take a look at that, because it explains in detail how you can assess the breaches and decide whether they require reporting on a case-by-case basis. So, just to summarise our overview of GDPR. So, it is going to happen. It's either as the regulation directly or under UK law that replaces it. The GDPR will come in one way or the other. There are huge risks to non-compliance, both reputational and financial, but considerable benefits for getting things right, for complying with the data protection principles and so on. And on that subject, it's crucial to comply with the data protection principles and handle your clients' rights correctly. Data processors and even software providers can be your ally or a liability, so choose wisely. Hopefully, all of this has been a useful introduction to GDPR. So just to kind of summarise our advice on this, here's a summary of the action points you could take. So firstly, just make sure that your management or board level, that they are aware of the regulation, and if you have a risk register, do include it on your risk register. It's on the radar, so to speak. Assign a data protection lead, even if you don't need a data protection officer. Get someone who's leading on it for you. Start raising awareness amongst your staff. Think about having formal structured training available, especially for those that handle personal data. If you don't already know the life cycles of personal data in your business, start finding out now. It will be impossible to prove that you manage personal data in line with the GDPR if you don't know where it is, how you get it, who you disclose it to, how long you keep it for, and so on. So you need to know where you are now, what you're doing with it. We discussed reviewing or looking at privacy notices. Think about whether they give enough information. Are they in line with the regulation? Document your working procedures and decision making around your use of personal data. So this is like the really important one, because even if you get things wrong, if you can demonstrate that you've given some thought about this, then you're much likely to be dealt with more leniently by the Information Commissioner. review your relationships with your contractors and your data processors, do a kind of health check on those. But also, finally, to make sure that you've got some, documented formal procedure for identifying and reporting breaches, and make sure your staff know about them. Aside from that, the information commissioner has published some guidance. They've got some useful stuff on their website if you haven't seen it before. So, that's somewhere you can start if the presentations raise questions about your compliance. But also, IRIS does have a GDPR portal that you can get more guidance from. So remember to ask your contact at IRIS for more information about that, to get the link and so on. So hopefully that has been a useful half an hour for you, just to kind of answer some of your questions, give you a bit of introduction to the regulation, hopefully not scare you too much, but give you some pointers over kind of the practical things that you can do. So that just leaves me to say thank you very much, everyone, for tuning in, if you like, and best of luck with your endeavours under GDPR.